Hi everyone, in today's video I'll be sharing the live stream that I did earlier today with the latest updates of Donna's case. I'm also including a segment from an older video where Ed reads the court's order denying Donna's motion for bond. Like I said, on June 6th there was a lot of fuss and confusion about Donna being moved. We had just posted the video about Sarif Yusuf's deposition that I read, and there was a lot of comments asking about Donna's supposed release, but she was actually just transferred to the Wakulla County Jail. So we did our own research and posted a pinned comment on that video that you might have seen, which basically said the docket shows that Donna was transferred to the Wakulla County Jail. WCTV reports it was at the request of defense counsel due to a new policy that would limit the ability of defense counsel to prepare Donna for the change of venue hearing, citing defense counsel Josh Zellman as a source of this information. Basically, it was hard for her to communicate, so they moved her. Yesterday, 2 entries were added to the docket in Donna's case that will probably lead to more confusion, so we're going to set the record straight. The 2 entries are 2 documents filed by the Leon County Jail concerning the release of Donna Adelson. Someone looking at those documents without knowing the full context may believe that Donna was being released from jail, but nothing is further from the truth. As you know, Donna had a bond hearing, which we showed here on this channel, and the bond was denied. So Donna was to stay in jail as she waited for her day in court, her trial. So the release documents that we are seeing concern the transfer of Donna from Leon County Jail to the Wakulla County Jail. So Leon County to Wakulla County. This was apparently done at the request of the defense and likely without objection from the prosecution. Also, it appears that this was done because the Leon County Jail adopted a new policy about the use of communication devices within the jail that would make it more difficult for the defense team to communicate with her, like I said. At least that's what they said on WCTV. Of course, Donna and the defense attorneys are probably made to about all of the investigation that had been happening at the Leon County Jail without them knowing about the apparent tip that Donna and Harvey were buying off witnesses. So I'll show you the documents, but even though they discussed Donna's release, she was not released. She was only transferred from Leon County Jail to Wakulla County Jail. In fact, just to make sure 100% that our reporting is accurate, I did call the Wakulla County Jail this morning to confirm that Donna was here. They transferred me to inmates, and I was like, I had never done that. So yeah, I did call the Wakulla County Jail. So yeah, the reporting is accurate, and yes, 5-car-5 case management is tomorrow, and we're going. Because of this change, Donna is likely to appear at subsequent hearings before the trial via Zoom, including tomorrow's case management conference and Friday's hearing on the motion to change venue, both of which we will cover on our channels, Mentor Lawyer Justice Network and Deep Dive True Crime. The Wakulla County Jail is also a bit nicer than Leon County. For example, Mentor Lawyer was able to meet in person with a client there long ago before his retirement from criminal law, in the middle of the night, something that would not be easily accomplished at the Leon County Jail. You'll see Ed's full reading shortly, but first, I wanted to highlight a portion that defense attorneys refer to in their motion to disqualify Judge Everett. This is the section that defense attorneys argue was not based on evidence presented during the bond hearing. Instead, they claim Judge Everett relied on information he encountered during the warrant application process as part of the so-called new investigation. Our team is currently working on gathering your questions for an upcoming Q&A video, and we'll have more updates soon, including coverage of the pending motion for rehearing. Now, let's watch Ed's full reading of the court order.
Order denying motion to set bond, Arthur hearing. This cause came before the court when the defendant sought review of her bail status based upon State v. Arthur. The court, having reviewed the evidence admitted during the February 26, 2025 hearing, the arguments of the parties, the court file, and being otherwise fully advised in the premises, finds and adjudges as follows. Defendant is charged by indictment with a qualifying offense, first-degree murder, and the state has, quote, come forward with a showing that the proof of guilt is evident or the presumption is great, unquote, State v. Arthur. The evidence from Charles Adelson's trial, the court presided over Charles Adelson's trial in Leon County case CF 3036B and remains very familiar with the facts and evidence of the case, quote, viewed in the light most favorable to the state, unquote, demonstrates, 1, the defendant's personal and unique motive to assist, cause, or encourage the murder of Dan Markel. 2, the lengths defendant was willing to go in the custody battle involving her grandchildren. 3, testimony by Catherine Magbanua directly implicating the role of the defendant in the payment of the murder for hire. 4, payments made by the defendant to alleged co-conspirators following the murder. 5, text messages and cell phone tower analysis demonstrating defendant's movements on the night of the murder. And 6, defendant's conduct after the law enforcement, quote, bump operation, unquote, and communications on authorized wiretapped interceptions. Defendant also exhibited consciousness of guilt when she attempted to flee to Vietnam prior to arrest using an emergency fast-track visa. See State Exhibit 6. This evidence of flight is admissible as consciousness of guilt, where sufficient evidence exists to establish the defendant fled to avoid prosecution. See Shalito v. State. After the state meets its burdens regarding Arthur, the court still retains the discretion to grant or deny bail. When determining this issue, quote, the burden is on the accused to demonstrate that release on bail is appropriate. It is with regard to this question that consideration of the likelihood that the accused will flee regardless of the sureties required becomes appropriate, unquote. Martinez v. Jones. In reviewing the evidence admitted during the hearing and applying the bail criteria of Section 903.046 Florida statutes, the court finds that one of the primary considerations of bail, ensuring the appearance of the criminal defendant at subsequent proceedings, cannot be met. One day after Charles Adelson was convicted of first-degree murder and other crimes, the defendant discussed fleeing to countries without extradition to the United States. See States Exhibits 4 and 5. That same day, defendant communicated with, quote, Vietnam Visa, Indochina Sun Travel, unquote, through what she believed was a secure communication application, WhatsApp, trying to acquire a, quote, fast-track emergency visa for Vietnam, unquote, and, quote, wanted it the fastest she could get it, unquote. See State Exhibit 6 and 3. The purchase of a one-way ticket and seeking a fast-track visa for extended stay in a country without extradition clearly demonstrates an intent to flee. The court does not find the testimony offered by the defendant during the evidentiary hearing on this subject to be credible, considering the evidence. Additionally, defendant's discussions of self-harm further negate the possibility of appearance for subsequent proceedings as directed by the court. The issues raised by the defendant concerning her conditions of confinement can be directly addressed through administrative and/or civil remedies. The testimony and evidence during the hearing clarify the reasonable measures taken by the Leon County Sheriff's Office to address defendant's concerns. Defendant is not being denied access to counsel or the opportunity to prepare for trial. The court also notes the defendant has undergone extensive trial preparation prior to the continuance of the trial on September 17, 2024 through the present. Done and ordered in Chambers, Leon County, Florida, March 3, 2025. Signed, Judge Stephen Everett, Circuit Judge.
And to wrap up today's video, I'm going to share the final portion of the bond hearing where attorney Jackie Fulford passionately fights for her client's release.
With respect to Arthur and every other defendant prior to Ms. Adelson being held and Arthur being met, Ms. Adelson isn't the prior folks. She's not the ones who showed up at Mr. Markel's residence with a firearm, who planned to kill him and then did shoot him at very close range and take his life. She's not them. There's proof there. They can meet their burden there. Clearly, that's not what Mrs. Adelson is even alleged to have done. In this case, did they hold Charlie? Yes, they did. They met his burden too. Proof against Charlie is very different. I'm representing, Your Honor, a woman who stands before this court, and the argument out of the state's mouth literally is what I put in my motion. She said some bad things about her future ex-son-in-law prior to the divorce being granted. She cut some paychecks out of Charlie Adelson's business, and it was her job to cut the paychecks. And at his instruction, she cut paychecks to Catherine Magbanawala. When her daughter called to say that her soon-to-be or her ex-husband had been shot and killed, Miss Adelson got in her car with her husband and drove from Miami to Tallahassee. And they're elderly folks, and that's a part of the record. It's a natural course of travel from Miami up to Tallahassee to go through the Orlando area. The state actually said in its argument that the time that lapsed between when they show the cell phone records of Donna Adelson and being near Charlie Adelson's house, and then when Charlie says he's going to get back, could be consistent with Mrs. Adelson stopping there and giving them this alleged pre-washed money. Could be consistent is not the Arthur standard. It's proof evident, presumption great. And they simply...
Proof evident or presumption.
Or presumption great.
Go ahead.
They don't have that in this case, Judge. What they have is the strongest, could be consistent with. Their entire case against Mrs. Adelson is speculation. The problem here is not one problem, that health issues are not being taken care of, or sleep is being deprived, or, she's not getting the food that she likes. Nobody's complaining about the fact that she's not getting food that she doesn't like. She's gained a third of her body weight. They can't protect her in the jail. They've testified themselves. There are no cameras inside the area where they use the restroom, the area where they take the shower, where these washing machines are. There are no guards in there. There's no video in there. So if she disclosed the name, which she's willing to do in camera to the court with nobody else present, because she knows she's going to be retaliated against, they can't protect her from retaliation. If they put her back in the annex and some girlfriends or friends of this woman that she rats out finds out that she's back in there, they can take her down in the bathroom, and the guards who are sitting behind a glass being protected themselves aren't even going to know it's happening until it's too late. So providing the name doesn't do that. I have a client.
Go on, Ms. Fulford. As to the sheriff's role in this, he has a constitutional responsibility to all inmates. Also, your client has the ability to pursue a writ of mandamus if the sheriff will not fulfill the obligations. Is there a reason this has not been pursued if the situation is, as you allege through your motion and testimony?
Because that's not the only issue we have, Judge, which is what I was getting to. What we have before us is a woman who's 75 years old. She's elderly. She has health issues that aren't being addressed, but there's more. She's not getting any sleep. She's given medication between 11:30 and 1:30 at night, maybe getting to sleep by 2 o'clock in the morning, waking back up at 3 or 3:30 in the morning. We're not asking that she get special treatment. She's on trial for her life in a town where everybody believes she's guilty. That for 10 years, it's been the same story, that the mafia mother has planned out this homicide and had Dan Markel killed on this evidence that could be consistent with, and that's not what we have. We can't prepare her for trial under these circumstances. Can we go and visit with her at the jail? Yes, we can. Do we have contact visits with her where we can prepare? Yes, we do. But we can't be up there 5 days a week. We can't be up there 7 days a week. We can't be there for lengthy hours. We're not the only ones who are requesting that time. When we got the records from the medical records from the state last week, there was one time that the jail was able to squeeze us in for 1 hour to go through the medical records with her. Over 300 pages of medical records. And we had other things to do in that time for us to meet with her. And I'm not criticizing the sheriff's office, and I'm not criticizing the jail. The circumstances are what the circumstances are. But if she remains in the jail, we simply cannot have her prepared to testify and assist with preparation of her defense. I cannot have an attorney-client privilege call with her there. It's the most frustrating thing in the world. This phone system that they have, they say that's not recorded, and we get cut off. It says we're making third-party calls. Neither one of us has made a move. Nothing's happening. We get cut off in the middle of the calls. She has this labored breathing. If they can't find anything in the x-rays, I'm certainly not a doctor. I don't know why she's got it, but I have to start yelling to have her to stop talking because she's breathing so loud, I can't hear a thing she's even saying. She did not flee. She did not flee prosecution. She was told, and witnesses for her were told, there was no prosecution. There was no warrant for her arrest. That it was perfectly fine, and the state knows this. That an investigator told a family friend, there's no warrant, they can travel. They didn't attempt to flee being prosecuted. They were told there was no warrant.
Is this part of the evidence that's in the record, or you're just making argument generally about this?
I'm making argument generally at this point, Judge, but the state knows it. If they're going to claim that she was actually fleeing, they know better. They know that their own office said it was okay for her to travel. And where did she get to? Absolutely nowhere. And they have absolutely zero evidence to rebut her testimony that she was not going to flee prosecution. She was just going to get away to clear her head. In fact, she thought she wasn't being charged. And that's all the evidence that she had. Now, if we were coming before you and she had actually fled and someone had to bring her back, I wouldn't put my name on a motion saying, give us a bond. But this isn't the first time that people have gotten a bond. Even people who fail to appear ultimately get bonds sometimes. Your Honor's aware of that. That does take place. People who violate their probation can get put back out while their hearing is pending for that violation of probation. If she has already surrendered her passport, she doesn't have a visa, she agrees not to drive, an electronic monitor is placed on her, she resides in Leon County, has to check in with pretrial as many times as you say she has to check in, can only leave for limited purposes, she's not going anywhere. And we're not asking, let's let her go back to Miami where she has an international airport that she can hop on and be gone before anybody knows that her bracelet is going off. We're asking that she be held right here, that she be court ordered to stay here with a monitor on, be allowed to be away from that home, to go to doctor's visits, get any medical treatment that she needs, come to court, be with her lawyers, and prepare her trial. We're not asking for a fancy hotel or anything else. And quite frankly, that's a little bit insulting considering the health conditions that she has to suggest that she's looking to be put up somewhere. The one thing the state fails to remember is she's presumed innocent. No, the Leon County Jail is not a Four Seasons hotel, but she's not supposed to be punished yet, right? She hasn't been convicted of anything.
There's a difference between pretrial detention
right. And she's been punished at this point. When you take not one of these things, but all of these things together, she doesn't stand a chance of being actually ready to testify for trial. That cannot take place under the conditions that she's facing. She's in extreme pain. She's not getting any sleep. Her diet is garbage. It's just not going to happen, Judge. And you know, if we were asking for something lenient, I could see the state's opposition, but we're not. We're asking for you to hold her outside of the jail in the most stringent conditions she could possibly be monitored, just to allow her to be with her attorneys, get her doctor's appointments, and get ready for the trial that her entire life depends upon. And I would argue the state has not met its burden. Thank you.
Very well. I will review the admitted exhibits before making a ruling. We are in recess. This concludes the hearings. You may take Mrs. Adelson downstairs.
Thank you for watching today's deep dive. If you found this case interesting or have any thoughts, feel free to leave a comment below. Remember, this community thrives on smart and respectful discussion. Don't forget to like, subscribe, and hit the bell to stay on track with our new case videos. We cover new details, court hearings, interviews, interrogations, and more. This is Maya with Deep Dive True Crime and Mentor Lawyer Justice Network, and I'll see you all in the next video.